Hi, everyone. Welcome to the show. Coming up, a knife-wielding man on the loose in a busy park. Police are called. We will speak live with an officer who rushed to deal with this dangerous situation. But first, a man convicted of murder for leaving his 22-month-old son in a hot car for hours is now asking Georgia's highest court to overturn his conviction. And I'll tell you, and I don't say this lightly, I hope the court grants it. I covered this case. Attorneys for Justin Ross Harris argued, among other things, that evidence that he was sexting with underage girls should not have been allowed into evidence. Prosecutors argued that Harris wanted to be rid of his son so he could live a carefree and child-free life. But I was never convinced that the evidence backed that up. Harris was sentenced to life without parole, plus an additional 32 years in prison for the death of his son, Cooper. The now 41-year-old told police he forgot to drop his son off at daycare on the morning of June 18, 2014, driving straight to his job at Home Depot without remembering that Cooper was still in his car seat. This case made national headlines, and many in the media were willing to convict him before the trial even started. But before the trial, prosecutors gave the impression they had a wealth of incriminating information regarding internet searches that Harris made regarding hot car deaths, animals in hot cars, and living child-free. But they didn't. The defense even discovered that he hadn't searched for any of it. Some of Harris's online history even played in his favor. The night before Cooper's death, Harris was doing online research about planning a family vacation with a child and whether or not kids could go on a cruise for free. There was also a claim about a child-free website he went on. Well, turns out someone sent him a link, which he responded, quote, grossness. Another issue was how police say Harris reacted. An officer testified that he never saw Harris cry. This is the video from that day that shows how Harris reacted.
I'm so sorry.
What is confirmed is that Harris searched for how to survive prison. But that may be because he was a sleazeball. He'd been exchanging sexually explicit messages and pictures with underage girls. He was not a good guy. And the court heard from multiple women he was having affairs with. But here's the key on the murder count. They were supposed to help the prosecution prove that Harris wanted to get away from his family. But they ended up saying the opposite. The jury learned that he told his mistresses that he wouldn't leave his wife because he loved his son too much. There were also compelling testimony from his ex-wife, who was obviously not happy with him as a husband, but said he was a great father. Do I think that Justin Ross Harris was extremely negligent and should be held responsible? Yes. He's now served over 7 years behind bars. But do I think he did this on purpose? No. Joining me now is Rachel Stockman, the president of the Law and Crime Network. She has covered this case extensively, and Rachel and I have talked about this at length many times. Rachel, what do you make of this case, and what are your thoughts about this appeal?
Well, first off, I just want to say this case is just horrifying. As a mom of a son exactly the same age as Cooper, going through some of the testimony of what happened to this little boy is horrifying. And I 100% agree with you, Dan. This guy is a complete sleazeball. He's a disgusting man who obviously was doing all sorts of affairs and things on his family. However, I agree with you. If you really boil down to what the evidence was that the prosecutors had against Justin Ross Harris, it's thin. There's not a lot there.
Let me play a piece of sound. This is from one of his mistresses. This is number 4. And this is her recounting a conversation she had with him about whether he would leave his wife.
Ross tell you if it wasn't for Cooper, he would leave Leanna.
Yes.
He loved that baby more than anything. And what was expressed to you, what Ross Harris expressed to you was that he wouldn't do that to his little boy. He wouldn't do that to Cooper.
Yes.
He wouldn't end his marriage because he loved that little boy that much.
Yes.
So, Rachel, as we watch this and we frame this in the way that I have, I know people who didn't follow the trial are going to ask, well, then how was he convicted?
Right. And I think there is one piece of evidence, Dan, that you didn't mention that I think is very damning. And that's the fact that after Justin parks his car with his son in the car, he claims he forgot. He goes out to lunch around noon with some friends, and he buys light bulbs, and he comes back to his car at around noon. So his son had been in the car for several hours and was probably already dead. He opens the front seat, drops the light bulbs in the front seat, and then leaves and goes back to work. Now, the prosecution argues there is no way he didn't smell the stench of death when he opened up that car. And I do think that raises certainly some eyebrows. However, I think all of this evidence is very circumstantial. And there is an argument, which is the defense's argument, that he just threw the light bulbs in there and he didn't look around. He was just running back to work.
And the prosecution actually went further at times. They seem to be suggesting that he was going to check to see if he achieved his goal of killing the child. And yet then when you watch the video of it, there's surveillance video, it does seem he's just sort of tossing in these light bulbs. Look, there's no doubt that this guy was, you know, if I'm right and if you're right, he's one of the unluckiest people ever, right? Based on all of the circumstances, all of the facts, all of these things coming together at once that look so bad for him. But, you know, I never thought that light bulb, the idea is that he wouldn't have smelled death in the car, and that he's buying light bulbs because he's checking to make sure that his son is already dead?
Yeah, like it was some kind of excuse for him to go back. But if you look at the surveillance video, like you mentioned, and you can see it, it's really quick. He doesn't look around. I can't tell he's looking in the back seat. And of course, you know, if you're not paying attention, you know, there is an argument that he was just throwing light bulbs in his car.
Let me play a piece of the prosecution's closing argument. This is number 2 from the trial.
We know that in these weeks after that vacation, leading up to June 18, 2014, at a time that his wife was asking him to come home and spend some time with her and Cooper because they were going to be leaving a few days later, he lied to her about what he was doing, and he went to a seedy Marietta hotel and had sex for money with a prostitute.
You know, I feel like I'm in a bit of a difficult spot, right? Because this guy is such a bad guy, right? And that some people are going to sort of hear all the things he did, texting with underage girls, having sex with prostitutes and this and that. And yet, you know, this is exactly what the appeal is based on, right? Is that the prosecution threw everything in the kitchen sink in against this guy, and that it essentially prejudiced the jury.
Right, exactly. That's their argument. They're saying, okay, why is it relevant that a year and a half ago or months and months before this incident, he was doing some of these things? And this so prejudiced the jury that they are so kind of jaded by this information, they can't clearly look at the evidence of the actual crime. And that is troubling because there was a lot in there, including, may I add, the fact that the prosecutors took sex that he had sent to a woman of his genital area and blew them up in huge posters for the jurors to take a very close look at. So there were some questionable moves by the prosecutors, for sure.
Yeah. All right. We shall see what happens. Again, this is one of these cases where I hope that you, the viewers, understand that I am looking at this from a legal perspective, what I think is very important legal analysis. I am not trying to somehow say, you know, poor guy. Although, anyway, I don't know. Rachel Stockman, Thank you for coming on the program. Appreciate it.
Thanks, Dan.
Coming up, a man is back from the dead. Literally. Well, almost literally. Tonight, we have new details on the guy who was celebrated for all his great work for kids when he, quote, died. Now we know why he faked his death, to avoid sex assault charges. And a woman he was convicted of attacking is speaking out for the first time. That's next. Last week, we told you the incredible story of a guy from Rhode Island who faked his own death to evade sex assault charges. He's been found alive in Scotland after being put on a ventilator with COVID. Many in Rhode Island, including the media, local politicians, and even his own family, believed that 34-year-old Nicholas Alaverdian had died in February of 2020 from non-Hodgkin's lymphoma. His life was even eulogized at the Rhode Island State House, where he was praised for his work fighting for children.
I could join in the memory of my friend, and I guess some of the people may know him also, Nicholas Alaverdian, who had a battle with cancer. And it touched me to be honored to get up to say something on his behalf.
But they have all now learned that they were duped after he turned up last month at a Glasgow hospital. Now, one of Alaverdian's victims is speaking out. The woman tells the Providence Journal she was dating Alaverdian in Ohio back in 2008 when they, quote, entered a basement stairwell at Sinclair Community College in Dayton, Ohio. When Alaverdian pinned me against a wall, she said, he began groping her and touching himself. The woman went on to say she questioned herself for pressing charges because he then had to register as a sex offender. She says, quote, but I thought, what if he attacked someone else? That was going to be on me forever. Alaverdian was eventually convicted in her assault, and prosecutors now say, just as his victim feared, that he went on to do it again, later the same year in Utah. But that case remained unsolved because of a rape kit backlog. Then in 2017, investigators clearing the backlog finally sent the kit for testing. They got the DNA results back a year later. They were then able to finally match the DNA to the Ohio case. So now, Alaverdian seems to realize the net's closing in on him. So in early 2020, he reaches out to multiple media outlets in Rhode Island, telling them to report on what he views as his impending death. Remember, he was known in the media as the outspoken child welfare reform advocate. That's why he was doing interviews with local media. A woman claiming to be his wife confirmed he died. An obituary was published in late February 2020. It quoted his last words as, quote, fear not and run towards the bliss of the sun. All of that seemed to work. Local news outlets reported that he had died. He was not dead. He was very much alive and fleeing law enforcement. The Utah County Attorney's Office says Alaverdian was able to avoid detection by using multiple aliases, including his birth name, Nicholas Rossi. They released a statement saying, in part, he has been taken into custody, and the Utah Attorney's Office is working with federal and international agencies to extradite Mr. Rossi back to Utah. Some of the families saying they were fooled, including his uncle, who planned a funeral after he received a request from women he thought was Alaverdian's wife.
Yeah, I'm shocked. In all honesty, I feel like I was used a little bit. I went along with it, meaning I was unaware that this was a setup.
Meanwhile, Utah officials believe there could be more victims.
We believe that there are other victims out there, whether those victims are in Rhode Island or in Ohio or in Utah or in Scotland or anywhere else this individual has been.
We were unable to track down information on whether Alaverdian has hired an attorney, but there is a new development tonight. Joining us now, a man who's been following Nicholas Alaverdian for years, investigative reporter Walt Buteau, now works for Nexstar affiliate WFLA in Tampa, Florida. Walt, thank you for coming back on the program. Appreciate it. So we're just learning tonight this guy is now out on bail in Scotland?
Scotland police let him out on bail. He has to report every night to police, but still he is free on bail. And we also know, great reporting by Tim White at Nexstar affiliate WPRI, and according to the Utah prosecutor, that at one point, Nicholas hired a private ambulance to theoretically take him out of the hospital. And you wonder what would have happened next, right? I mean, you could think, yeah, he hires the ambulance. He gets to tell the ambulance where to go. The judge in that case, I'm told, figured it out, and it didn't happen. But he is now free and potentially thinking of ways to get out of Scotland. We do know from the prosecutor in Utah, he got into Scotland illegally under the name of Arthur Knight. So could he get out of Scotland illegally? That's something that I think prosecutors in many states are watching.
Well, that's stunning. And look, neither of us, I don't think, know bail law enough in Scotland to understand exactly what led them to release him. But talk about a flight risk. I mean, this guy is the walking definition of a flight risk.
And he's very smart, by the way. You know, he won a settlement or was awarded a settlement in federal court. He represented himself. He sued the Child Care Agency of Rhode Island. Imagine that. That's been done in many states unsuccessfully. He sued and won a settlement, an undisclosed settlement, with in federal court. So he's filed many lawsuits on his own. He's a smart individual, well-read. And I'll tell you, yeah, there's no doubt. And I said this to somebody I talked to earlier today, a police officer. He's going to think about how to get out of Scotland every minute of every single day. I mean, his chances, who knows how good his chances are at this point.
Yeah, I mean, because one of the things, you know, when we wrote the script as an introduction to this, we said that the Utah authorities have said he's now in custody and they're going to work on extradition. I would think the Utah authorities have to now be very concerned about the fact that he's not necessarily in custody.
No doubt about that. And while they're concerned, so are no doubt police officers in other states. I know that the Utah prosecutor had said that three other states, there may be cases in 3 other states. He mentioned Massachusetts. We had heard about a case in Massachusetts probably in February, a short time after he reported his death, or his death was reported by his wife, quote unquote, Louise, who called me, woman's voice, and told me he had died. We did run an obit that we took down maybe 3 weeks later as things started to surface. But yeah, no doubt, not only the prosecutors in Utah, but perhaps some other prosecutors who have open cases.
Now, Walt, what made you suspicious, right? I mean, you've been following this case, you've been following this guy, you've been very involved in this. What started to tip you off that maybe his death wasn't for real and there was more to this story?
So it seemed weird right away. But me and another reporter who had been working on this, he's now with the Globe, Dan McGowan, had talked about the way we received these calls from this woman, Louise. Louise, you could never call her. She could only call us. And you hear from people who use voice changing devices that is protocol. It only works if you make the phone call. That was one issue, but also a big one here. His Wikipedia page kept changing. And there were details that perhaps only Nicholas would know. There was a spoofing outfit out of Great Britain who got in touch with me. They were suspicious within about 3 weeks. People in Ohio got in touch with me saying, it just sounds like Nicholas is making these changes. His wording, he had a unique, he was very smart, perhaps would insert a $50 word every so often. Yep. So all those things sort of led us to that conclusion.
Walt Buteau, thank you. Thanks for the good work on this. Appreciate you coming back.
All right. Thanks for having me, Dan.
Coming up, the pettiness between our cable news friends reaches new heights. So much so, many of them won't even call the other by their proper names. Yes, that's now a thing. That's next. Time now for our Mediaite Moments, where we check in on the day's bias, buzz, and bull in the world of cable news and beyond. Here's one thing we know. Fox News loves to beat up on CNN and MSNBC, who in turn love to beat up on Fox News. It's just good for business for all of them. But these days, the players have become remarkably childish in the ways they deride one another. Take, for example, some of the talent at CNN who now refuse to use the name Fox News when citing their competitor.
They're not in on the joke. They're not in on the joke that Tucker Carlson is in on, that he is a joke. Elsewhere on Fox Entertainment Television, they didn't like how Vice President Kamala Harris said that January 6th will be added to the list of dates in American history that will live in infamy.
And it's not just the network that gets the diss. Check out how Anderson Cooper references his 8 p.m. competitor.
And in that spirit tonight, I give you Senator Ted Cruz assuming the position last night before Fox entertainer Tucker Carlson, who had already raked him over the coals the night before.
And if that insult was somehow lost on CNN viewers, Don Lemon was a bit more explicit.
That is the question after Senator Ted Cruz grovels to a host on the Fox Propaganda Network. The Fox Propaganda channel loves to attack. They're taking their cues from the Fox Propaganda Network.
Not surprisingly, some at MSNBC play the same game.
The Fox Propaganda channel did not cover tonight's hearing live and
must bow down to Fox News, which operates as a propaganda machine for the party of Trump.
The Fox News channel is not a news channel at all. It's a propaganda network.
And also not surprisingly, some at Fox play that same game, echoing insults created by former President Trump.
Now, for the past year, if you turn on fake news CNN or MSDNC, it's pretty much all that they talk about. Even MSDNC's top Democrat, Chucky Todd, take note. Look at this headline from fake news CNN.
I guess this stuff resonates with the hardest core of the viewers on both sides. And now, as we try to welcome the political middle, we criticize all of the extremes for the way they criticize each other. And so it all comes full circle. That's our wrap-up of the day's media bias and buzz in the Bull. Coming up, even the highest court in the land not immune from the fight over masking, with Justice Neil Gorsuch apparently refusing to wear a mask despite a request from his colleague, Justice Sonia Sotomayor. That is coming up. The ongoing legal drama surrounding Republican Florida Congressman Matt Gaetz appeared to take a significant turn last week as his ex-girlfriend, with whom he was apparently in an open relationship with between 2017 and 18, testified in Orlando before a federal grand jury investigating the congressman on possible charges of sex trafficking a minor, violating the Mann Act and obstruction of justice. CBS News now reports that the woman was granted immunity. It's the latest sign the investigation into Gaetz, which was opened under then Attorney General Bill Barr in the final months of the Trump administration, is active and potentially perilous for the Florida congressman. The investigation centers around the congressman's relationship with a woman who was 17 at the time, and whether he gave the teen money or goods in exchange for sex. But investigators are also looking into whether Gaetz potentially obstructed justice during a phone call with his ex-girlfriend and another woman. Gaetz has vehemently denied all allegations against him, saying he's never paid for sex, never had sex with a minor as an adult. When reached for comment, an attorney for the congressman told us that they have, quote, no credible basis for Gaetz to be charged. Gaetz's ex, who has not been named to protect her privacy, is considered critical to whatever case prosecutors might make against Gaetz. According to CBS, she has information related to both the sex trafficking and the obstruction allegations. Other witnesses to the congressman's alleged crimes are less than ideal, to put it mildly. First, there's this guy, Joel Greenberg, former friend and wingman of Gaetz's and former county tax collector who once falsely smeared a political rival as a pedophile. Last year, Greenberg pled guilty to multiple charges, including sex trafficking a minor, same teen Gaetz is accused of having sex with. Greenberg admitted defrauding the Seminole County tax office out of hundreds of thousands of dollars, using county money to buy cryptocurrency, sports memorabilia, using an office credit card to pay women he met on a sugar daddy website. The investigation into Gaetz was spurred by the charges initially filed against Greenberg in July of 2020. That's how it all started. The other witness is the possible victim herself. Her current career, reportedly in hardcore porn, could make her a tricky witness to a jury in conservative Central Florida. But even with the testimony of Gaetz's ex, any case may not be a slam dunk. prosecutors have to prove that nearly 5 years ago, the congressman had sex with a minor and paid for it. Now, I will tell you, I hope that prosecutors are very careful and deliberative before filing any charges against a high-profile political figure like Gaetz, who's already claiming the investigation is political, even though it was launched during a Republican administration. The problem for him could become a legal one. Paying for sex with a minor automatically triggers sex trafficking charge, regardless of whether the adult thought the person was of legal consenting age at the time, or whether they showed a fake ID, etc. So where do things go from here? Let's bring in Kendall Coffey, former U.S. Attorney for the Southern District of Florida. Kendall, long time. Good to see you again. All right, how big a deal is this?
Well, it's a very big deal. Immunizing somebody who seems to be a key witness at this stage of the investigation tells you that if 212 is the boiling point for an indictment, they're at about 210 or 211.
So you think, I mean, because there's been a lot of speculation about what it means or not means, but you believe this is that close to an indictment of Matt Gaetz?
I think the testimony that they've apparently received from an immunized critical witness who could say a lot of things about what he actually knew, put all the pieces together, is a very big deal. And it may be the final piece that they need. Doesn't mean they're not going to run down some things that she talked about, make sure they check everything out. And it doesn't mean there won't be some period of negotiation with Gaetz, because there usually is before you launch an indictment. But I think it looks like most all the pieces are together and that this case is heading toward indictment.
So he's been under investigation for more than a year now. And, you know, this guy Greenberg gave them what he gave them a while back. Why would this take so long?
Well, Greenberg's going to be an awful witness for the prosecution. They've got to rely on him to cover some points. But just as you described a few minutes ago, it's one thing after another, corruption, really creepy, weird stuff, and certainly a lot of falsification. They can't ride that horse to the finish line. But if they've got plenty of other evidence, they've been looking all over the place for the last year, and then they've got a relatively credible ex-girlfriend who maybe could be a critical witness here, they have a triable case. Doesn't mean we know everything. There's a lot of things we don't know, but that's how it's shaping up from the outside.
Let me ask you, if you're in the spot of the prosecutor who's making the decision on whether to charge, when you're dealing with a high-profile, highly political case, you're going to dot all the I's and cross the T's before you indict, right?
And then some. And I'm not going to bring a case that relies principally on Joel Greenberg. I'm going to rely on a case that expects an onslaught of very aggressive criticism, accusing, of course, this being a Democratic ploy. But at the same time, I'm going to do what's right. I'm just not going to take a chance on a case that depends too much on Greenberg. And I'm going to bring in the obstruction and the false statement claims if I possibly can, because, as you know, those issues often get the conviction. Sometimes it's not what you did, but what you fibbed.
Yep. All right, we shall see. Kendall Coffey, good to see you again. Thanks for coming on the show. Appreciate it.
Great to see you, Dan.
Coming up, the fight over masking has made its way to the Supreme Court. Yep, justice versus justice, not a case in front of them. That's next. Apparently, the differences between the justices on the U.S. Supreme Court are getting personal. Justice Neil Gorsuch apparently refusing to wear a mask during court proceedings, despite the fact that Justice Sonia Sotomayor, who is type 1 diabetic, has expressed concerns about being near unmasked people. Now, out of respect for Sotomayor, Chief Justice John Roberts asked the other justices to mask up. All have done so, except for Gorsuch, who happens to sit right next to Sotomayor on the bench. As a result, Sotomayor is no longer attending a weekly conference among the justices, and she's phoning in instead. So Gorsuch, remember, is the 2017 appointee of former President Donald Trump, has developed a sort of prickly reputation during his time on the court. He ruffled feathers right from his first proceeding in 2017, tried to tell his more experienced colleagues that a particularly complex case was actually very simple. He's taken regular shots at Chief Justice John Roberts. He's gotten into a number of petty disagreements with colleagues, both conservative and liberal alike. But this mask issue speaks to a larger problem of civility on the high court. Remember when late Justices Ruth Bader Ginsburg and Antonin Scalia, who agreed on practically nothing from a legal standpoint, maintained a close friendship outside of work. Ginsburg, progressive icon, Scalia, conservative hero. The two saw eye to eye on very little, and yet they had immense respect for each other. Look at the obvious affection between them during this joint appearance in 2014.
I have never gotten angry at Ruth or at any of my colleagues because of the way they voted in an opinion. I mean, if you cannot disagree with your colleagues on the law without taking it personally, you ought to get another day job. I mean, it's just not the kind of a job that will allow you to behave that way. So Ruth and I disagree on the law all the time, but it's never had anything to do with our friendship.
And we do also have a difference in style. I'd say people might regard my opinions as rather dull, boring. Yours are really jazzy sometimes.
Jazzy. You know, their ability to put aside the partisan differences helped set an example for the rest of us to follow. Which brings us back to Justice Gorsuch's refusal to mask up for Sonia Sotomayor. Look, I appreciate that people have different views on masks. And I also agree that sometimes insistence on mask wearing can have a bit of a virtue signaling feel to it. After all, certain types of masks in particular have been deemed useless against the Omicron variant. But this feels like a case of reverse virtue signaling by Neil Gorsuch. Even if he thinks it's useless or silly, why not just as a matter of common courtesy, just agree to do it? Joining us now is Jess Bravin. He's covered the Supreme Court for the Wall Street Journal since 2005. He knows this court very well. Jess, thank you so much for coming on the show. Appreciate it. What is your sense of why Gorsuch is being so insistent on this?
You know, Dan, it actually surprises me because both Gorsuch and Justice Sotomayor have relatively sharp elbows for the Supreme Court. And in a while, you know, for early in Gorsuch's tenure, they actually seemed to get along with each other better than they got along with other members of the court. In fact, both of them made joint appearances promoting, of all things, civility. Both of them work on this project called iCivics that retired Justice Sandra Day O'Connor pioneered. They've been on TV together. So it really does surprise me if Gorsuch is specifically refusing to do this when Justice Sotomayor is asking him to wear a mask. It seems it's a surprise, but it is certainly true that you know, the different personalities on the court, some people look for consensus and common ground. Justice Gorsuch is not someone who does that. He knows what he thinks is right, and he is going to pursue that no matter what. And perhaps for him, that's a form of courage.
Let me ask you this. Do you think the fact that this has now been made public could potentially put pressure on Gorsuch to say, you know what, I was never saying I would never do it. It was just an instance of, you know, one or two times, et cetera. I don't know, whatever the answer might be. But do you think that the fact that this has gone public could change it and potentially resolve it?
Well, it was always going to become public because it was quite public that he wasn't wearing a mask. Everybody else was in the courtroom. He wasn't. She wasn't there. Now, the fact that there was a link between those two was not obvious at first, but inquiring minds certainly wanted to know why she's not there and why he is not wearing a mask. So it was bound to come out in one form or another since it was right in front of us and in the sketches that everyone else could see from the Supreme Court. Will it pressure him? You know, I wonder. I mean, he's not someone who's known for backing down. He's not someone who's known for seeking compromise. On the other hand, he has stressed that civility is an important virtue in his mind. Perhaps he didn't see it this way. Perhaps he saw it as some other way.
Why can't they just move seats?
Well, you know, if you've been to law school, Dan, you know that you have assigned seats in most law school classes. It's the same thing at the Supreme Court. There they do it by seniority, and there is a very rigid sequence by which they sit. And when there's a new justice, they all move different seats. So I think that the court would not be interested in doing that. And besides, you know, she's not the only person in the court who may feel uncomfortable with one unmasked person when everybody else there is wearing a mask.
Right. You could just see, one of the other justices saying, whoa, I'm not, this moving stuff isn't going to work for me. I don't want him next to me. Anyway, it is surprising and disappointing, and hopefully it will get resolved, because I do think it's bad for the country when there are these sorts of squabbles on our high court, which both you and I have such reverence for. Jess, thank you for coming on the show. I appreciate it.
You bet, Dan.
Coming up, a night at the park takes a terrifying turn when a man with weapons, including a knife, frightens families out for the night at the movies. Officers quick to get on the scene. One of them will join us live to take us through the video. Coming up. We're on scene tonight with the Newark, New Jersey Department of Public Safety, showing you the dangers that police officers face every day. The officer involved will join us in just a moment. It happened during movie night in a park when someone saw an armed man.
Where? He's over there. Where? Right here. Where's he at? Right here, right there. Right here, right there. Put the knife down.
Witnesses, you can see, pointed out the suspect, Marcelino Cantarero, to Officer Christopher Adams. He saw the man with a knife and a pry bar, immediately told people to get away as the officer followed the suspect.
Everybody get back! Knife down! Get back! Leave! Forget that chair!
As more officers arrived at the scene, they gave space to the suspect. As he walked in front of parked cars, officers walked behind them, eventually to an open area.
Everybody watch the Watch the fire! Tranquilo! Tranquilo! Put it down! Bájalo! Bájalo! Bájalo!
Now, you saw that. Police used a construction barrel for protection, then threw it at Cantarero, knocking him to the ground. Officers used pepper spray, took the suspect into custody. No shots fired. No one was injured in the end. Cantarero was charged with unlawful possession of a weapon, disorderly conduct, and resisting arrest. I'm pleased to be joined by Officer Christopher Adams, who you saw there, and Newark Public Safety Director Brian O'Hara. Thank you very much for coming on the show. Really appreciate it. Officer Adams, let me ask you if you could just take us through this. It's a busy night at the park, and then someone yells at you, and what happens next?
Yeah, someone approached our vehicle, me and my partner, and, quickly just a movie night turned into mayhem. So my partner and I, we exited the vehicle, we seen the guy, and then our first priority was just clearing that park. It was kind of an open space. And we used that space as our resource, cleared the park, and the public was, out of the way.
Now, you followed the suspect, right? You're following the suspect. You're yelling at him repeatedly to drop the weapon. Let me just play a little piece of that one more time.
Put the knife down! Everyone get back! Get back! Drop the knife! Get back! Leave! Leave! Forget that chair!
Now, you mentioned again giving him the space. Talk to me about that, about why you did that.
Well, we gave him the space just to, we wanted to keep him visible, but keep our distance from him. And as long as that, that park we used as our resource, open field, and we knew a lot of people can run, but he can also run towards the people. But we wanted to keep eyes on him until we got other people we could surround him, and that's exactly what we did. We surrounded him with that space. So we used the space against him.
And Director O'Hara, your department has put new de-escalation techniques into practice. This seems like a perfect example of a situation where you want to de-escalate, you want to figure out how to get him down without using any force. Talk to me about it.
Well, look, obviously, this was an extremely volatile situation. I'm incredibly grateful for the way that Chris and his fellow officers performed that night. But I think, people talk about de-escalation. It's a buzzword that's been common. But de-escalation is a little bit different here in Newark. It's something that we've been working on, longer before George Floyd was murdered. I feel like over the last year and a half, policing in this country has become very focused on what police officers cannot do. Time after time, new policies come out and say officers can't do this, they can't do that in regards to use of force. What we've been doing here is to try and focus and retrain our officers on what they can do. Because I think generally across the country, people talk about de-escalation and they think it's something that's only verbal, and that's not true. Sometimes people pose a legitimate threat to public safety, and our officers need to be prepared, and they need to be able to know what they can do physically, what's within those parameters, so that they feel confident in situations like this. Because look, this is a situation, obviously, where Chris and his partners out there challenged conventional thinking. Right? There were plenty of times, if you watch this video, where these officers would have been legally justified to use very serious, if not deadly force against this person. And what they did was just the opposite. They improvised. They evacuated the park. They continued to move the person, created time and distance, space. They got cover and did everything possible to get additional resources there. They got an opportunity. They improvised. They used a construction barrel because everything else was not working at the time, and they safely took this person into custody. And I think that clearly is changing the narrative, at least in this city, about what police officers do and how they work when they're interacting with the public.
Well, look, and Director O'Hara, every night on this show, I do a segment like this to show people what policing in America is like and what is important to do, not do, et cetera. But it's about understanding how police face danger every day and how they have to deal with it. And I think that this is a perfect example of a situation where you guys have shown us and you have talked to us about how important training is, how critical it can be, and it was. And we appreciate it. I'm out of time, but I appreciate what Officer Adams did here. I appreciate the focus that you're putting on this. I think it's incredibly important. Thank you so much for coming on the show.
Thank you, Doug.
Thank you.
Thank you for watching. Click the red subscribe button below so you can get more of News Nation's fact-driven, unbiased coverage.